Good morning, everyone. It's Grant Abbott speaking from I Love SMSF and also LightYear Docs, and welcome to this very exciting launch of our new service, SMSF Wills, with a death benefits trust option. For those of you who have attended last week's session, which was on wills and testamentary trusts, you've got a really good understanding of where we're coming from in terms of the delivery of our data capture for wills and testamentary trusts, and more importantly, the documentation there. As I said, for those who did attend last week, I will be giving you a credit in order for you to do your own will and testamentary trust, so you have a really good understanding of where we're coming from. Again, this is a brand new opportunity and brand new process for you to take control of the client's estate planning affairs, both SMSF and also non-SMSF and family trust or discretionary trust for that matter, in a very simple, easy to use data capture format. And it provides, because it's all done in a line with the same data, etc., as we go through, and a good understanding being the same advisor, that we end up being providing a safety, security and certainty for our clients, which is absolutely crucial. Now, following on from last week, I suppose the main element for most of us is the concept of a binding death benefit nomination. I switched for many years into a concept called binding death benefit directions. And really, having drafted up the will along with Tony Anamourlis at Abbott-Family, we sort of sat down and we had a look at what was required in a will, the executor, the ability to do specific bequests, to actually set up, for example, life tenancies, and also to obviously build testamentary trusts out of the will, and really took a lot of that format processing understanding and started to build it into these binding death benefit directions. And then it struck me is that, well, if we're going to do this, is a term I used way back in 2007, that if this is akin to a will, then why wouldn't we just call it an SMSF will? So that if your clients understand that your SMSF sits outside their estate, their wills and their testamentary trusts, then this is the same sort of process we're going through. Instead of an executor, we're looking for someone who's the replacement trustee or replacement director and the trusteeship. Instead of a testamentary trust, we've got a death benefit trust, which I'll go through. Instead of specific bequests, we can still do specific bequests here. It just has to be done in a certain shape and form. So I've actually got a very good process now for us to use. Through this session, I've got quite a few slides to go through to get you up to date. Then I'm going to build an SMSF will. And then from that, we'll actually go through the SMSF will, have a look at the shape, the key features of it, so you get a really good understanding. I would highly commend, obviously, for all of you who are on our unlimited program or licensees to really go and practice as much as you want on the platform. It is now sitting up there. So start to build one for yourself and also start to get an understanding and build it for your clients. Anyway, this is from last week and really hasn't changed. I mean, for us, the key elements really for our business structuring, if we've got asset protection, are going to be our discretionary trust, which is perfect. It's also going to be our bucket company and also our SMSF. Now, they've tended to be all standalone vehicles, but we're finding now, particularly now we've got T-bar and accumulation, etc., that they're all starting to blend together. We're doing joint ventures between family trusts and SMSFs. We're setting up 1322C trusts and companies between the discretionary trust and also the SMSF, and switching units over. And for those of you who've been on our the roadshow or the strategy, you saw amongst the 20 strategies I did on that day, that effectively there's a lot of toing and froing between the family trust and the SMSF. They work seamlessly together, which is absolutely crucial for us as advisors. Now, as an adjunct to that, obviously, we've got the will and testamentary trust, which really sit outside both of these vehicles, governed by state law, whereas the discretionary trust obviously is governed by state law, but really is an entity unto itself and can't be governed by the will, neither can the SMSF. So we've got a really good element there for asset protection, but also what I call will protection. So what we're seeking to do is obviously protect our estate from the ravages of the legal profession in the event there's a challenge to the will. We don't want that bleeding over to the SMSF, and we don't want it bleeding over to the family trust, and that's crucial. Now, as of right here, the added bonus of both the discretionary trust and also the SMSF is asset protection, of course, tax concessions. Now, SMSFs obviously outbeat, in most cases, trusts, but still, trusts are still a really good vehicle for us. Now, the most important task for both the trustee and SMSF is really to build in succession, as well as plans of what has happened on the death of the member or the appointor. And I'll be looking at that in terms of the SMSF will, because this is one of the parts of the binding directions that we're actually going to include in there. Now, the good thing about it is if we do it well, we do get safety, security and certainty, and that the estate can't be challenged. So really that will put the poor old lawyers at a disadvantage, particularly the ones who've got no win, no fee. They won't come within a bull's roar of an SMSF will. For us, the SMSF will is a perfect for SMSF assets and provides a protection of the SIS Act, which I'm going to have a look at. And essentially, where we do an SMSF will, which is a set of binding directions and a nomination, effectively it's akin to a federally mandated binding contract between the trustee and the member. And you can't get better than that, particularly when there's potential criminal penalties for breaching the SMSF will. You don't get those for a normal will and testamentary trust. So that's why I love these vehicles. So we've talked about this before. Last week we've looked at wills. We've previously looked at discretionary trusts and leading member discretionary trusts and appointors. Today we're going to have a look at SMSFs and structuring them for succession and also estate planning. The good thing about this is, I'm going to keep on raising this, is that we are your strategy engine and we do start to put a lot of documents together. So next week, if you're around next Thursday, we're going to be releasing the enduring power of attorney, which you've already seen. And all of these videos are now sitting up in our resources section, in our support section up on our LightYear Docs website. We're putting our EPOA together with our will and also with our SMSF. So that is going to be a really awesome product, because you'll actually do the three of them all in line. You'll be able to do an absolute full estate planning suite for your client, which now means that you're in control of the process. You've got liberation, so you don't have to go and spend time waiting for lawyers to draft up things and spend countless hours, them not knowing an SMSF. You're putting the whole thing together. So it provides freedom and also succession for your clients. The thing I love about it is safety, security and certainty. So what's the difference between a BDBN versus SMSF will? Essentially, and I know there's been a lot of talk around BDBNs, and I'm not really a great fan of it. I saw Dan Butler give a session at the class conference and virtually raised maybe about 10 cases where BDBNs have been struck down. Now, mind you, obviously Dan's one is quite a powerful one, and he's been around the industry for a long time and knows his stuff. So, I give him his absolute dues on that one. But look, I'm not a big fan of them, mainly because the very term binding death benefit nominations are really for industry and retail funds. And to use that term inside an SMSF, Jim Lane sort of brings down the concept, and SMSF is a premium vehicle for our clients. Both the Commissioner of Taxation in his guidance in terms of death benefit nominations, I think it's 2008/3 or 2, provides that effectively the laws, section 59(1)(a) of the SIS Act, which brings into account a binding death benefit nomination, along with SIS Regulation 6.19, do not apply to self-managed super funds. And that was reaffirmed by the Supreme Court, as you can see, the Queensland Supreme Court in Donovan and Donovan. So it's fairly well settled law that two things there is that one is that your estate, your will that you drafted does not and in no way can impact the trustee of the SMSF, because that is governed by the SIS Act. And more importantly, the binding death benefit nomination rules in the SIS Act do not apply to a SMSF. So with those, obviously we've got to look at, well, what does? And for that, the Commissioner and also the courts have basically stated that it is the governing rules. So, for example, there's been a number of cases whereby the process and the system, for example, in Katz and Grossman, there was a binding death benefit nomination supposedly to transfer all the monies to the legal estate, whereas to be split between the deceased daughter and their son 50-50. Now, the daughter was the trustee of the fund and then proceeded to take all the money out of the SMSF, the whole $1 million or thereabouts. And obviously it was challenged by the son, saying it should have come to the estate. Now, quite rightly, what had happened there is that the in that case, the deed itself said that any binding death benefit nomination had to be in approved form. Now, unfortunately, the trustee of the fund had no approved form, and the letter that was issued by the member, the deceased member, Mr. Kratz, to the trustee of the fund, effectively, although it went through all the processes about making a binding nomination, wasn't effective because it wasn't in an approved form. So we really need to sit down and have a look at what our deed says to obviously put in place an SMSF will or death benefits trust. And of course, we've embedded those direct terms and processes and systems and strategies around that into the LightYear docs deeds, which we'll look at a little bit later on. Now, when we have a look at it, the reason that we want the document being a binding contract to become part of the fund's governing rules is, if you've seen when we looked at a while ago these sections, and certainly we looked at them in detail in the roadshow. And just as an aside there, for those of you who attended the roadshow and would like to get a copy of the 5, it's quite extensive, it's 4.5 hours of the roadshow, which was filmed at the last session in the Gold Coast. I'll talk about that a little bit later on, and also talk about it for those of you who didn't turn up. It's a must-see when we start to go through. But I spent a lot of time in there talking about Section 54C, which basically provides in the legislation that no person can breach any part of the governing rules of the fund, which includes the trust deed, and obviously would include a reversionary pension, would include an SMSF will, anything else that we set up that manages and deals with the management operation of the fund, the maintenance of the fund effectively. Section 54C provides that can't be breached. Now, it's not if we turn to Section 55.3 and also 54C, it's not an offence, and it doesn't invalidate the transaction. So, for example, I talked about it when we had a look at reversionary pensions, that we might have, for example, on our death, and we've got a second spouse in the fund, that we pay her a pension which is akin to an allocated pension, a non-commutable allocated pension. So it's a non-commutable allocated pension for a period of her life, which is much the same as a life tenancy, always non-commutable, so she can't capitalise it out, and at any 1 year not being able to take out more than 15% of the income stream by way of a pension. Now, and on death, effectively any monies left over are to go to the dependents of the original pension member. So if we put that reversionary pension in place and effectively it's signed off, it's executed, again, it becomes a federally mandated binding contract under the SIS Act. Now, if the second spouse, for example, is an overseas resident, simply takes all the money out of the fund, it goes overseas and lives overseas, then there's quite clearly been a breach. Now, effectively, that means the beneficiaries who have missed out can effectively go and make a claim under Section 55.3 for loss or damages in relation to the fact that they're potentially missing out. The big issue for them is what is the quantum of loss or damages that they are missing out on, particularly when their benefit is contingent upon there actually being monies left in the fund upon the death of that second spouse. But notwithstanding that, there is a direct action against the second spouse for loss or damages. Now, from that one, particularly if we go a bit further, because she's scampered overseas and is, obviously knew that wasn't able to. Effectively, there's potential criminal offence under Section 202. So there's a bit of typo there. So the potential imprisonment there is for a term of no more than 5 years. So again, with the SMSF will, when we put it down, which is a set of legally binding death benefit directions, what we've got there is we've got something that has got the force of the SIS Act, and more importantly, 54C and 55(3), and namely anyone who, and listen to this very carefully, anyone who has lost anything as a consequence of a breach of those governing rules to recover. And I'll come back to that one. So I'll just reiterate once again, Section 54C says it is a breach of the SIS Act for any person, whether it's an accountant, a lawyer, for example, a member, any person to breach the governing rules. Now, we've talked about it before, reversionary pensions are part of the governing rules, as is the investment strategy, as is the SMSF Will. So if there is a breach by any person, including the ongoing trustee of the fund, where we've got the deceased member, if there's any breach, then there's recovery against any person who's involved in that breach directly for loss or damages. So anyone who feels aggrieved, we're going to come back to that one and use it quite powerfully. So SMSF Will is part of the governing rules, which is crucial. So it's as I said before, it's a set of legally binding death benefit directions and nominations for a member that's akin to a federally protected contract under the Superannuation Industry Supervision Act. It's interesting because it's also, if you have a look at Section 9 of the SIS Act, that effectively anyone who breaches the SIS Act, because it's federally protected, can also be caught under the Commonwealth Criminal Code. And that would include anyone who aid and abets someone who offends or breaches the SIS Act is also liable to exactly the same penalties under the Criminal Code. Now, that would then go back to the spouse who's obviously overseas. Hard thing there would be to actually recover if they're already overseas and outside the jurisdiction. But that's where a good advisor needs to step in on the death of the deceased member and take full control of the estate planning process. Importantly, because of the SIS, to date, we have a look at Donovan and Donovan, Katz and Grossman. There's been so many cases where the courts have been trying to, not the courts, the defendants have been trying to pierce the SIS Act and their governing rules to effectively provide that the deceased will has greater power than that. And every time they've basically been shot down. So that's a good thing for us, because it also means that if we get our structure right in our SMSF will, and we don't pass anything to the estate, which is my preference. I prefer honestly, if I go back, and hopefully you can see this, if we go back to this, I prefer dealing with the SMSF directly, and at the last, if there's no one around, then passing anything over to the will. But if I can deal with everything inside the SMSF, which includes specific bequests, which can include pensions, auto reversionary pensions being built in there, and an SMSF Death Benefits Trust, which actually is built down below the SMSF, then effectively that's protected by the SIS Act, which is really for us is all important. In the last 2 or 3 weeks, I've seen a number of cases where there's been challenges to the SMSF, and unfortunately the lawyers on both sides weren't really aware of the power of the SIS Act, and plus there was no SMSF will, and it's cost between $150,000 to $200,000 in legal fees in order to get directions from the Supreme Court, which is a crazy scenario, if you ask me. Better to be safe, certain, and secure. So when we have a look at it, that in the LightYear docs SMSF deed, so that's our standard deed. And if you're looking to protect lineage or bloodline, you really want to have a look at the leading member SMSF deed, which I'll look at very shortly. The SMSF will is encapsulated in there as a set of binding directions and a whole range of options, which we'll look at when we go through the LYD SMSF will data capture process. As I said before, the SMSF will, you can prepare the SMSF will as part of your role as an advisor to the fund, particularly those of you who are licensed under the Corporations Act. It's just the same as doing a binding death benefit nomination, so it's exactly the same process. But we will be, as I said before, encapsulating the EPOA, the SMSF will, and also the will and testamentary trust for your clients. You'll be able to pick an option under our automation where you'll be able to do the whole three at once. Now, importantly for that one, generally we find that with wills and testamentary trusts, it's important to get a lawyer to sign off on those, mainly under the Legal Professions Act, not so much the SMSF will. EPOA, we've used the state-based forms to basically get around that. But look, if you're going to go down the track and do the whole three together, then it's probably worthwhile, rather than just do the will and testamentary trust, do the whole three together. And then one of our lawyers, you can have a Zoom meeting with the lawyer and the client, which is a great process. And we'll have a review of the will and TT, the SMSF will, and the EPOA based on your data capture. And the sign-off cost on that is $495. Now, in terms of the three together, the EPOA, the SMSF will, and also the ordinary will and TT, that will come as a bundle package of $245. So it's a pretty good deal if you ask me. So SMSF death benefit trust rules are part of the governing rules, as I've said before, mainly safety, certainty and security. For the death benefits trust, much the same, what happens is it pops out of the SMSF, as we'll see later on. So what it is the trustee, or effectively the replacement trustee, under the LightYear Docs SMSF deed and also the leading member deed. What happens is under the will, and also under the deed, the executor is automatically appointed as replacement trustee or replacement director on the corporate trustee, and they are the only ones who can make any decisions around the deceased's superannuation benefits. So it's basically ring-fenced in there, and they're the only ones who can make valid trustee or binding trustee decisions in relation to that. Now, what we do is we give them the power, as you'll see, to create a discretionary trust on the death of a member, and I'll go into terms and conditions around that. But effectively, that pops up out of the SMSF, and then you as a professional advisor will set that up. It's called a death benefits trust. So in the instance we'll look at it, we'll call it the Smith Death Benefits Trust for Matthew Smith, and I'll have a look at that a little bit later on. So that's essentially where we want to go for that one. But it's a discretionary trust. It's not a testamentary trust from a will, so that if there are any minors, they're going to have to pay tax at the normal minor penalty rates. But the easy way around that is to employ them as minors. That way you can then do salary sacrifice contributions and not distribute, as you would have seen on the roadshow. The final one before we get into the SMSF will itself, the leading member SMSF death benefit process. So I've got a really good podcast that I put up last week with John Grokey from Johnson Grokey in Adelaide, who's a 3 or 4 partner firm with 25 staff who are doing really well on leading members, charging anywhere between $3,000 to $6,000 to set up or renew or update an existing SMSF into a leading member SMSF or discretionary trust. So have a good look at that. That's up on our resources section on I Love SMSF. So have a look at that because really John gives away the whole, his whole process, how he deals with the clients, the feedback on them, why he's getting almost 100% success rate, and what he charges. And really, hat tip to John for being really providing such valuable information for all our advisors. So make sure you have a look at that podcast. Alternatively, you can just go on to I Love SMSF or do Grant Abbott on Spotify, and you'll find that will pop up. Now, with the leading member, what happens is that where we have a SMSF, we have a leading member, and I've talked to you about that. If you haven't seen that session, again, go onto our support centre, you'll see the leading member video on there. But on the death of the leading member, it instantly passes to the next leading member in the fund. So, for example, in the event of my death, it passes to my daughter, Sophia, who's 21 years of age. And that means that now she basically controls that superannuation fund. Now, the problem that we have a lot of it, and I saw a $200,000 legal case on this just recently, which is scary, that with a SMSF, that when we have a corporate trustee, and think about this yourself, where there's a corporate trustee and someone dies, then effectively the shares in that corporate trustee form part of the deceased member's estate if they're entitled to the shares, which can then get caught up in probate, can get caught up in any challenges, and can really stuff that whole fund ad infinitum for quite a period of time. And really nothing can be done in that fund if those shares and potentially the trusteeship, because obviously the shareholders at an AGM can replace the trustee. It's like the appointor version. So to get around that, what we've created is the leading member corporate trustee for an SMSF. In that instance, we're going to have the leading member in the SMSF, who is also the chairman of the corporate trustee and also the sole shareholder. So that on death, the succeeding leading member, who's generally going to be the executor and the replacement director, effectively the leading member's shares, the original one deceased, their shares cease straight away, are cancelled, and new ones are issued to the new leading member. Now, this is on death, but also can apply where, for example, the original leading member wants to retire, loses capacity, etc. So that's exactly the same process, and that's for safety, security, and certainty. And at the end of the day, we don't want any legal challenges. We don't want to be tied up for 18 months at a time, effectively having to go into expensive litigation, and litigation is crazy around an estate. So again, the main thing is here, if we do have a good succeeding leading member, then effectively, as soon as the deceased member dies, we can put in place the leading member and start to make distribution of benefits along with a professional advisor nominated in the will. We can start to transfer all the superannuation benefits out very quickly. In fact, it should only take a week or two, and we'll be building a process for that in our strategy automation. And as a consequence of that, before even we get to the executor or we get over probate, everything can be sorted out with the SMSF and everything's distributed. So it's impossible to challenge when there's nothing left inside of that fund. Anyway, without further ado, let's just go in and have a look at our LightYear docs. So what I've done here, you can see is an SMSF Will. I built one before us, just so I've got a bit of time. Now, I've downloaded that document. We'll have a look at it, but what I want to do is open it up so I can show you the data capture that you'll be completing. So if you've already got it, you can see here anyway that I'm a LY strategist, which means I've got unlimited use, particularly if I'm a licensee. And if you're not, really, honestly, with all the stuff coming out, it doesn't matter where you are, you really need to get on top and be part of the LightYear Docs program, because we're not only miles ahead of everyone else, we're miles ahead of the rest of the world in these things. So we go to my vault. I did this, as you can see, these are all our, basically all our folders. I did this under the Abbott-Family. So I just simply click on that. And that will pop all my documents, and you can see here, the last one I did was the SMSF Will. You can see before, I've done this before, during power of attorney, account-based pension. Remember, we did that last week. So to relaunch and make changes or see what I've got, I'm just going to simply, you can see I did that this morning at 8 o'clock, which is Queensland time. So I'm relaunching that interview process. So let's just go through and see what we've got here. So this is the information that you're going to request of your client. What I will do is I'm going to take you through a couple of new features we just launched in this whole system you may or may not be aware of, but it certainly cost us a pretty penny of almost up to $500,000 to put these in play with this specific version of our documentation. You can see here the interview outline. We've got our where does this sit in the vault? So it's quite clearly the Smith Test Fund, which basically you saw came up in your folder. So once it goes in the folder, you want to be able to identify it pretty quickly. So we've called it the Smith Test Fund. We're going to go to the member, the trustee nomination, so on and so forth. So they're all the issues I'm going to look at. So I want to go to next. So this is the members' details. So we want to put in the name of the superannuation fund there. We want to put in the date of the application. If you don't know it, because you don't know when the person's coming in. So this is the application to start an SMSF will. This goes to obviously the trustee of the fund, who then has a meeting to make it binding and make it that federally federal contract. We put the members' details sitting in there. We then go to our next. So we're going to go next button or below. I just like this is quicker. Go to the trustee. I've just picked up everyone from the roadshow. So again, you make sure you get that video recording. It's awesome. So a couple of things here. I've put in 3 directors, confirm that. So I've got John, Sally, and Matthew. Remember, Matthew is the son who's taking over the farm. I've put in there, I've ticked each of those to sign on behalf of the company when it comes around to binding. I want them all to sign. And if I leave any blank, then they don't come up on the signing pages. So now we hit the road. So this is where the SMSF will is completely different to a binding death benefit nomination, because we've actually got 6 key variables there that we'll have a look at. The first off is, do you want to revoke any earlier BDBNs? Do you want to revoke any wills, etc.? And this really follows straight out of an ordinary will where we revoke earlier wills. So it seems to me, why wouldn't we want to put that in place for our SMSF will? Just makes sense to me. Otherwise, we don't want to have challenges that, well, this other one that we did is still applicable. So we go yes there. Now I know my friend Dan basically in their deed, he has their binding death benefit nomination. Again, I don't like that term. Always overrides a reversionary pension. So in that instance, if you want to go down and close down all reversionary pensions on death to be basically substituted by whatever's covered under the binding death benefit nomination, then we put that. But for me, look, I believe, as I said before, it's very dangerous, because if we've got a reversionary pension, as I said before, that effectively it is a binding federally mandated binding contract on the trustee to then at a later date put in place a version that overrides that, and then to complete that, I really think there's potential legal action under 54C, 55.3 and potentially 202. If we then go down to the next stage there and we have a look at it, actually here's a really good one from Harry. Good to see you again, Harry. To what extent may an endowment policy underwritten by an old AMP cover may be affiliated with a SMSF policy in the member's name with therefore this cover? In fact, Harry, that's funny. I just did. Here's an interesting one for you. Tony and I met with a client yesterday, was actually referred on to us by one of our licensees who doesn't want to go down the track of doing estate planning because they work in a different area. Anyway, they referred the client on to us, and she's a lovely lady, and they really wanted a will and testamentary trust to be done. We had a look at what had been prescribed for her by a solicitor over in Western Australia, which took 18 months and it's going to cost $1,500 to prepare, which is crazy. I tell you the truth, I was giving a presentation yesterday at Shaw and Partners in Sydney to the great guys there, and we're going through all of this process. And honestly, having a cup of tea downstairs, I completed the will and testamentary trust in no time. One of the ones there, Harry, which is the same here, is that the client in question had an insurance policy. What we want to do is, we've got an insurance policy, we want to go in and nominate the child or dependent or whoever we want to get that asset, so that the insurance proceeds go directly to them rather than going through the estate. Unfortunately, the insurance policy can't go through the SMSF unless If it is sitting in the SMSF already, absolutely we can handle it under our specific bequest if we want to do when we have a look at that. So if it's sitting outside the SMSF, we can either put it into the will and testamentary trust, which probably means it may well be challenged, or alternatively, we can place it into directly in the name of a nominated beneficiary, which again means it's not subject to challenge. So we've talked about replacement trustee, replacement director. Yes, we want the executor to come in. Again, safety, certainty, security. In the LightYear docs deed, they're the only ones who can vote and discuss the distribution of a deceased superannuation benefits. Now, here's the next one. Does the member want to include death benefit payments? Well, that's going to be pretty obvious. Does the member want a professional to look after your estate? Guys, if you're a professional, always go yes. Now, what will happen is if you go no, then that part of the SMSF will effectively just drops out. So I'll go through the whole lot and I'll tell you what drops out. And then do you want to catch all escape clause in case the super benefits are not payable due to possible non-compliance of the fund at the time of death? So what I've got there is it's called the nuclear option, and I've never seen that before. But you know, if the fund is being hit by non-compliance, then all of this effectively is invalid. And so what we want to do is want to have a catch-all clause. So I've gone down this track. So I've made all my nominations. So this is still the member doing this. So you're actually asking the member. So the next time we'll go through the process, and I will go through here. So this, remember, is for the member accumulation account only. So even if you ticked the box in relation to here, that if you said no, so does the member want a reversion? If you say no, then what will happen is that pension then rides over to the accumulation side. So a SMSF will only ever deals with accumulation side. So here, do we want to have a specific bequest? So this is, again, follows really much the same as a will. So I've got Matthew Smith, who's the son who's working on the farm. So what I've got there is the farm's at Terramunga Mine. In fact, it's an old father-in-law of mine. It's a lovely property in Terramunga Mine. It's a very famous man, Maxwell, was in Dubbo. A family farm, so it could actually be passed down directly out of the fund to Matthew Smith. Now, what we'll do is you'll see when we get into the document, does Matthew want to have it directly in his name, or preferably in an SMSF Death Benefits Trust, or alternatively, you can actually transfer it over into the estate and get it passed through as testamentary trust. Remember, hopefully, when we have a look at it, we've got Matthew Smith would be the leading member and would be obviously the executor as well. So in this instance, we'd want to make sure that when John dies, Matthew Smith is the executor. Now, we then go through much the same as we would with a will. Who's going to be the main beneficiary? So in this instance, Sally Smith is the spouse. She's the main beneficiary. So I'll just put spouse, which is a wee bit more politically correct, but look, I don't really care. Now, we've got there is a lump sum or income option. Honestly, if you want to pay a lump sum, you're better off doing up in a specific bequest because that comes out first rather than doing a lump sum of the residuary. So if you understand that, lump sum, if you want to go to Sally Smith, so in this instance, I'll go Sally Smith, spouse, asset, $100,000. So do that rather than the lump sum. For the income option, absolutely. So what we want to do there, an income option, because it's a spouse, it is really open-ended there. And what I mean by that is that she can take it as a lump sum, she can commute the pension, so on and so forth. I'll go through a couple of interesting ones around that as well. Now, alternatively, if it was a second spouse, remember I talked about that before, so I can put in terms and conditions the pension, to be paid to Sally Smith on the death of John Smith is to be a non-commutable allocated pension with any reversion payable transferable on her death to any of my dependents. And that would be under the SIS Act. In fact, I could put so as per the SISA 93, who will take jointly and equally. So any of my dependents at the time of my death, as per the SISA, who will take jointly and equally. So what we're doing is we're limiting the amount of money. So that's a life interest. So remember how we have a life interest for property, where I think we looked at Sally Smith could live in the property for her life. Well, here what she's getting is an income stream for life only, and anything is to be transferable on her death to my dependents. Alternatively, it could just be transferable to the estate. So the estate can be opened up at that point in time. So I've just got a quick question here. Okay, so again, thank you again, Harry. If we have a look at it, if it's an old AMP policy, make sure that you go and have a chat with AMP to see who the nominated beneficiary. But again, questions like that, please feel free to contact me, grant@ilovesmsf.com. So if Sally's not alive, what happens then? This is the residual beneficiary. So it's exactly the same as a will. So this is where you can start to understand where I've got the concept of the SMSF will. So the residual beneficiary is Matthew Smith. Now, what happens is it can pass, if Matthew's not there, it can pass to his children. So if it's a residual beneficiary, then they're under age 25. What's the maximum drawdown? So I've got 15% there. So it's just 15%. Go to the next. So this is that's the whole thing. Now you want to put your professional details in. So I've got Jim Gronk, what your normal fees are. You can actually be like a public trustee, or what a lot of lawyers do, charge a certain amount of your super benefits as a percentage, a set fee amount, or normal professional fees. So that now becomes part of the governing rules of the fund, which means that if you are subsequently sacked by the trustee or the incoming trustee of the fund, you can then recover under section 55(3). Pretty smart, eh? Can you believe that? Absolutely important to put that in. We then go down and we have a trustee meeting. So this is the SMSF will we've created. Now we have to have a meeting with the trustee to sign it off. So I've got John, Sally, Matthew there. John's the chair, and we've got the address for the meeting. And then we go to, obviously, the next page, which is actually going to set it up. Can I have a testamentary trust under the SMSF BDBNB? No, it's just, unfortunately, it's a death benefits trust, which is a discretionary trust, which is the same. In fact, you can create all the terms and conditions you would under a testamentary trust. The only difference, as we'll see when we get into the document, is that minor issue. So that if, for example, Matthew's children, and it's for Matthew, take any benefits out of there, or there's a distribution there, that effectively what we've got is they're going to be taxed at minus rates, hence we want to have employees. Now, a few new features here. Save answers, go along the way. I always save answers because sometimes if we get interrupted at work and what happens, and because this is actually a legal document automation process, it tends to time out. Obviously, you'd need that for most legal firms. So it's set to a timeout in, 5 or 10 minutes if you leave it uninterrupted. So make sure you save your answers. A couple of new features we've put in place here. You can actually preview the document. So before you go ahead, if you want to have a look at what the document looks like, just simply go here, and there you go, you've got SMSF Will. Now, it's not perfectly formatted and all that, but you can see there's the PDS, and then we go down to the SMSF Will here, and we'll have a look at it anyway, but it gives you an idea of what the layout is. You can go back and, of course, go back to the interview and make any changes. Another way to make sure you're getting all the data right is we've installed this new feature, which is an answer summary. So you can see there in all the interview, the data capture you've done. We've got all the details there of the trustee, of the SMSF directors, Director 1, Director 2, the nomination directions. We've ticked X, we've got what the death benefit payments are. So again, you can go back there, you can print these off if you want. So it's a very, very advanced feature. And again, hats off to Ashley and her team at LightYear Docs for implementing all of those and now launching. But we're going to go back to the interview. I'm really happy with all those for the client, because what I want to do is get it out, get it in draft form, send it off to the client for their review. And then we can come back and go through the process of what we want to do. Next week, you're going to have a lot of fun, because we're going to be doing EPOA, wills and testamentary trusts, and SMSF wills all together. So watch out for that one. So I download the document, which is in our PDF. So up it pops. For those of you who are our licensees, we did have LightYear Docs as the logo, but we've taken that off now because it's signed off by Abbott-Family lawyers. But for those of you who are licensees, I think we've got about 30 of them now, you'll have an option again, Ashley and her team have put that in place, where you'll be able to put your own logo in here for this self-managed super fund SMSF Will. Again, that's not going to have an impact from a legal perspective, because again, it's prepared by TGA Legal, trading as Abbott-Family. Again, what I would suggest is that if you're going down and doing the whole three in a line, the EPOA, the will and TT, and also the SMSF Will, you want to probably do a Zoom with a client. That way it passes. You'll still be able to charge $3,000, $4,000, $5,000 for doing the whole process, or whatever you want to charge for those three documents. But now it falls on Abbott-Family, so it's definitely worthwhile. So the product disclosure statement for SMSF Will, really at the end of the day, SMSF Will is a member's set of binding death benefit directions and nominations, and may be referred to as just the SMSF Will, which is what we do. As I said earlier, 2008, in fact it's /3, the payment of death benefits from a super fund is determined in accordance with the governing rules of the super fund, not in accordance with the terms of the deceased will. So we go down here, there's quite a lot. This in fact is just taken straight out of my my book, The Guru's Guide to SMSF, which I'm currently updating to a family SMSF book. There's Katz and Grossman. Remember, we talked about that. So again, we then go to what are the key components of an effective plan, payment of death benefits, so who can get paid. So this is something for your client to read beforehand. Who is dependent, which is crucial. Remember, we looked at family allowances and family allowance agreements and dependency declarations in our system. So make sure you have a really good look through here. We've got the Commissioner's ruling. We've got Malik's case here, which I love. And also we've got, in Malik's case, Afgis and Carney, which is a High Court case. So it's pretty authoritative. We've then got Foll's case, regulated guideline. You only need partially. In fact, if you have a look at the APRA guideline, there's no need for one person to be wholly dependent on one another for that person to be dependent for the purpose of the payment standards. Financial dependency can be established where a person relies wholly or in part on another for his or her means of subsistence. I love this one. Nor must the recipient show a need for the money received from the deceased member in order to qualify as dependent. Moreover, since partial financial dependency can generally be sufficient to establish a relationship of dependence, it's possible two persons will be dependent on each other for the payment standards. So that to me is absolutely awesome, particularly when we look at financial dependency is part of the tax rules. That effectively means that if we find financial dependency based on this, using a family allowance agreement, using dependency declarations, then there is none of that 17% tax on the taxable component of any death benefit payment. Anyway, let's go down to the SMSF Will, and I've got in there LightYear Docs deed, what's an SMSF Will, the things you can and can't do. So this is an application. Remember we went through this by James Smith to the trustee of the fund. So let's go through. So this is where everything pops up. I hereby revoke all earlier binding death benefit nominations, so on and so forth. Reversionary pensions to take precedence over this B2BN. This needs to be updated to SMSF wills. I'll do that. But anyway, that's just coming through very shortly. If I tick no, that wouldn't popped up. So this would have been number 2. Appointment of replacement trustee and member. The executors of my legal estate are to be appointed as my replacement trustee and to stand in my shoes as members of the fund until the final amount of my superannuation death benefits are paid. If there's no executor, then there's to be no replacement trustee. If there is a company trustee of the fund, my executor is to be appointed as a director in relation to distribution of my super benefits upon my death. Should the corporate trustee choose not to appoint my executor as a replacement director, the trustee is resigned as trustee no later than 3 months after my death. Again, remember, this is part of the governing rules and is caught under 54C and 55.3. So if they fail to appoint the executor as a director within a 3-month period and they don't resign as trustee, then it means the executor can sue the trustee for loss or damages, which I believe in this instance could be quite significant. Anyway, go down to death benefit payments. Lineage, as defines the direct lineage descent of the deceased member only, but may include any other person deemed to be a lineage beneficiary. So specific bequests, we've got Matthew there, the son, the family farm, and Sally Smith, the spouse. There you go, I can't even put spouse right. I've made a typo, which is good. We can go in and change it really quickly. Now, importantly, this is where the Death Benefits Trust comes in, Harry. These specific bequests may be transferred directly to the designated beneficiary, so we can transfer the family farm. Matthew's executor, as soon as his dad has passed away, can transfer that farm directly out of the SMSF down to Matthew. In most instances, it shouldn't be subject to stamp duty. Or it can transfer it to any trust, company, or person, or any or other entity the beneficiary directs, including a transfer to the deceased member's estate for the assets to be held specifically for the beneficiary or in a trust. So we can pass over the estate for the testamentary trust, but if we do, just bear in mind, now Matthew's executor controls it, it may be subject to legal challenge. Coming out this way, then there is no legal challenge if it's paid directly. At the direction of the beneficiary, say Matthew, or any leading member, the trustee may create an SMSF Death Benefits Trust to hold the designated bequest. The SMSF Death Benefits Trust is a discretionary trust whereby the beneficiary or their assigners will be trustee and appointor. Further, the beneficiary is being designated primary beneficiary of the trust along with any lineage or such other beneficiaries as the beneficiary includes a constituent trustee. The exact terms and conditions of the SMSF Death Benefits Trust will be determined upon advice. So this is where you guys come in, any professional engaged in the estate. So that's pretty crucial there. So what you do is you basically set up a leading member, a discretionary trust, and call that the Smith SMSF Death Benefits Trust. Now, apart from that, so there's specific bequests. We've got main beneficiary, we've got income stream there. Now, ordinarily, this as you saw, I put this in. So wherever you put that filling in, we complete that, that actually pops up as a separate clause in there. Then I've got Matthew Smith. So again, he's to receive anything. So if Sally's not alive, he's to receive anything, and then he can basically do whatever he wants with the money. Same thing, Death Benefits Trust. If any residual beneficiary is not alive at the time of death, their share of my death benefits will be paid to a settlement SMSF Death Benefits Trust for the benefit of my lineage. And if there's no lineage, then it goes to the estate. And again, as I said, if any residuary beneficiaries under 25, then it's non-commutable to age 25 and a 15% drawdown. So there's no main or residuary beneficiaries alive. Remember, we've put it in a Death Benefits Trust. Then effectively just goes to the estate for my lineage again. So we'll see what happens there. Now, the nomination of the professional for my super estate, you've got John Gronk. Again, if we go in, the executor says, look, I don't like John, which is a problem and needs, obviously, we need to continue to update him, particularly if he changes accountant and you're coming in, you want to make sure there's no clauses like this, which it can be built into the SMSF rules of binding nominations. So what will happen is that if it's not there and effectively is, if Jim Gronk isn't appointed, then he can take an action under section 55.3. And again, if there's problems with non-compliance, then it's just to be distributed in any way, shape or form as the trustee wishes. So, and then we go from there. So that's your SMSF will. And then you've got a trust resolution to accept the member's SMSF will in event of their death. So they basically attach that, which is attached, they sign off, and then it becomes binding and it becomes part of the governing rules of the fund. So it's a pretty comprehensive document. For those of you who've got unlimited membership or licensees, so you're otherwise strategist or a licensee, go in and fill in your own details for your fund and have a really good look over, because there's so many strategies involved here. So look, it's a great addition. No one else is doing it in the marketplace, but it's very strong and at the end of the day provides safety, certainty, security. So just to wrap up a few things, We've got a new suite coming up, a new strategy automation. The SMSF Will is up and running now, so we can do that effectively as we want. But next week, EPOA Will and Testamentary Trust and SMSF Will, generally they're all $99, but next week we'll be able to get the whole three in one line for $249. And that honestly will save, because you only have one common set of parties, that is going to save you. You'll see next week when we do it, as long as you know the data that you want to put in, and we should go in and I will build a data capture for all of these probably by next week. Then in effect what we'll do is from that data capture, you'll be able to then complete the whole process in no more than maybe 15 or 20 minutes in a draft form. As I said before, go to ilovesmsf.com and have a look at the video. I think I've got, if I go up to, where is ilovesmsf.com? Okay, so if I go to ilovesmsf, that's the roadshow. So let's just go back. So if I just go to ilovesmsf, so that's already over. So where we want to go, a couple of things I want to show you while we're here. Go to Learn podcast, have a look at that one if you're not used to it. Leading member, have a look at that. Basically, you can play that straight off, or go to Spotify if you want to listen to it while you're in the car. October Roadshow, you can find there. You can go into the roadshow. You've got, oh, we've already got that. Sorry, you need to go to the shop. Silly me. If you go to the shop, you can buy my book. I think there's only like 20 copies. I've got a new one coming out. So you can buy the roadshow recording. If you are actually did attend, use the roadshow all in caps because you can get it for $49 there. And effectively add that to the cart. There's 5 modules there. It's 4.5 hours, absolutely crucial, great training. Just spend some time training all your staff on that one. If you want to get 6 hours of CPD, which follows this, you have to complete a survey post watching this, and you get, that's an additional $50 if you want to go through the training. And might as well throw in the document as well. So have a look at that. That's certainly worthwhile picking up and looking not only for that, but going on obviously down into the future. I've also got a EPOA letter to send out to your clients to highly recommend that they do their EPOAs for superannuation purposes. Most of your clients' EPOAs are completely ineffective to put in place replacement trustees and directors, so it's a good chance to go and tell your clients about that and get them to update it, particularly with Christmas in mind. And mind you, you might as well, I will be doing a wills and testamentary trust, SMSF Will and EPOA letter to cover the whole 3 there, so you can then send them out to your clients. Alternatively, you can just say, look, we're going to do your EPOA first, your will, and then your SMSF Will. But again, you can do the whole thing in a line and just bring them in at different times. For those of you who are on unlimited packages or not using a suite, look, it's great. Thank you for support under POIG. But there's so much extra benefits if you're getting if you're on a license. If need be, make sure you contact me. Anyway, it's Grant Abbott signing off, and unfortunately we can't get CPD for these because we're actually talking about product, which is really strategy, and showing you how the documentation, which to me is the most important of all. But unfortunately, we can probably give you FASEA CPD. We just can't give you SMSF Association and also FPA CPD. But certainly if you're an accountant, there's absolutely, you can write this down as an hour of CPD under CANS, also CPAs. Anyway, that's enough from me. I'm really looking forward. Can't wait. Make sure you book in for next week when we're going to bring the whole thing together all in a line, which will be super exciting. And look, for you guys, you're right at the front of the pack. This is a great opportunity to turn into complete estate planning specialists, take control of things for your clients, and really start to make a difference in their lives. Safety, security, and certainty. That's what they need. That's what we all need. It's Grant Abbott, signing off.